signing non-disclosure agreement may be considered by the inventor or the applicant in order to control misappropriation of invention disclosure. And before filing patent, it is suggested to search prior art whether the related invention published in public domain, either in patent literature or non-patent literature. So it may save time, efforts, and fund of the inventor or the applicant, although it's not a compulsory requirement by the government side. Once it seems invention may be okay in order to get patent, we need drafting of the invention, that is patent drafting. It is called patent specification, the document called patent specification. After that, we may proceed for filing for patent. There are two options, online and offline. There are around 10% discount in online filing in order to promote online filing. After filing, government publish the patent applications after expiry of 18 months. If like, inventor or applicant may request for early publication along with some prescribed fee like 2,500 rupees for individual startups and with educational institution. Application published within 1 month. After publication, applicant need to request for examination within 4 years from the date of filing application, and this is a compulsory requirement, otherwise application will abandon. After disposal of the examination, the application either on the merit accepted or rejected. So regarding the process and timeline, there are two options, early publications and publication after 18 months. And after the publication, there is an option of opposition by any person interested. There are two types of opposition, pre-grant opposition and post-grant opposition. As name indicates, pre-grant, any person interested may request for opposition till the grant of patent, and in post-grant, within 1 year of the grant, a person interested may request for opposition. Such opposition matter decided by the controller of patent. And the minimum document required for patent filing in India is Form 1, 2, 3 and 26. Form 1 is the application for the grant of patent. It includes name, nationality and address of applicant and inventor, title of invention, and signature of applicant and inventors. Form 2 is the specification. There are two types of specification, provisional and complete. It includes title and detail of subject matter, fully and particularly description of the invention, disclose the best method of performing the invention, claims for, abstract drawing if any, model or sample of anything illustrating the invention as the controller may require. Form 3 is the statement and undertaking and detail of corresponding foreign patent applications. So जो भी related applications applicant ने submit की हो in India or outside, he need to submit all such details. Even अगर कोई applications ऐसी ना भी हो तब भी ये form 3 submit होता है with nil information. And form 26, that is power of attorney. These are the minimum documents required at the time of filing. After that, if applicant wish to proceed further, there is an option for early publication on form number 9, and he may request for examination within 48 months On Form 18 and Form 5, that is declaration as to inventorship or proof of right. It required in case where applicant and inventor are different entity, so that applicant here declare that who are the inventor. And this is regarding government fee. Application for grant of patent for natural person, MSME people and educational institution 1600, and for other it's 4000. There is no extra charge after provisional to make it complete. On Form 3, statement and undertaking, there is no any government fee. To declare inventorship, there is no any charges. Request for early publication, that is 2500 for individual or MSME, educational institution, and it's 10,000 for others. Request for examination of application, it's a 4,000. There are further some forms which may not be required in every case. It depends on case to case. Like in case of extension of time, Form 4, change in applicant, Form 6, notice of opposition, Form 7, mentioning the name of inventor, Form 8, amendment of application, Form 10 and 13. So this is the portal where we may log in and file online application. For this we need DSC, digital signature. We may select either the new application or form number 1 in order to proceed filing application for patent. Who are the applicant? Section 6 of the Patent Act indicates who can file patent application. It may be an individual or natural person, no matter whether Indian or foreigner, small entities under the MSME Act, any legal entity like a company, no matter again whether Indian or foreigner, a startup, or above may jointly file the application for patent. This is sample of power of attorney issued from the applicant in favor of the agent. It needs to be fully signed both by the applicant and his agent. Form 1, that is application for grant of patent. It includes information like applicant detail, inventor's detail, detail like name, nationality, address, title of invention, and declaration by the inventors and the applicant. There are some declarations like we are in possession of the above mentioned invention. The provisional or complete specification relating to the invention is filed with this application. Invention is disclosed in the specification uses the biomaterial from India and the necessary permission from the competent authority, that is NB National Biodiversity Authority, shall be submitted. There is no any lawful ground for objection. I or B, the applicant, or the assignee of the legal representative. Application or each of the applications, particularly of which are given in part of 5 was first application in convention countries in respect of the present invention, and later list of the attachment with the application like complete specification, drawings if any, priority documents if any, translation of priority documents if required, a statement and undertaking on Form 3, power authority, declaration of inventorship on Form 5, etc. So this is one of the field form, Form 1. Details of applicant, detail of inventor. See here both the applicant and inventor are same person. Further declaration by the inventors. There is no need of such declaration here because this is the same person. So inventor here is the applicant too. So applicant no need to declare about the inventorship. At the last page, bottom, applicant or the agent on his behalf need to sign the form. Next is form number 2, that is patent specification. In case of provisional specification, we need description of the nature of the invention, which contain essential feature of the invention. No need to include claim and detail of the manner in which it is to be performed, while in complete specification, all such details needed along with the claim. Claim is one of the most important part in the complete specification. This is the format of Form 2. On the cover page, we need title of invention, applicant detail, and preamble of the description. As per the kind of specification, whether provisional or complete, preamble vary. Like in case of provisional, preamble is the following specification describe invention, while in complete specification, the preamble is the following specification particularly describe the invention and the manner in which it is to be performed. From the next page, there is a description, and at the last, there are claims and abstract. So this is Form 2. See, title, applicant detail, and preamble. So a specification includes description and claim. Description includes title, cross-reference, if any, background of the invention, includes further field of invention and description of related arts, brief summary of the invention, brief summary of the drawing, detailed description of the invention, abstract drawings, the sentence framed during the patent drafting, a field of invention. The present invention relates to, generally we use title of the invention, and further we restrict the scope or narrow down the scope of the invention. More particularly, the process is for making so and so. The present invention particularly relates to a process of making so and so. Here we may include inventive step and novelty of the invention. So these are very particular information in the field of invention, and in the background part of the invention, they are prior art, both patent literature and non-patent literature. After that, we highlight drawbacks of the prior art, and based on that, we may frame objective of the invention, what drawbacks may be removed by the present invention. So what the solution present invention providing in order to solve a problem. A summary of the invention, brief description of the drawing, detailed description of the present invention. Generally, things are not perfect, so whatever examples we covered in the specification part may not be adequate enough for every person. So we need to give some declaration here, like the following example are given by way of illustration of the present invention and therefore should not be construed to limit the scope of present invention. So अगर 4-5 एग्जाम्पल देते हैं तो जरूरी नहीं क्या हमारा इन्वेंशन की लिमिट उसी एग्जाम्पल तक सीमित हो. एग्जाम्पल बहुत हो सकते हैं, but for the sake of convenience, all such examples may not be mentioned under the specification part. So claim, as per the kind of inventions, the claim may vary. For IT related inventions, the language of the claims is like a method of performing motion estimation in a digital video system so and so, computer readable medium sorting, storing a set of instructions so and so, a method for decoding a bit stream or a bit stream comprising of so and so, a method for computing a motion vector, the method comprising so and so, and for a invention quick cement checker. In the first claim, it is claimed that the invention is non-conventional, economical, portable, and useful to detect quantity of cement in cement sand mortar within 30 minutes of adding water, and so without any burden of the cost, and the checker is consisting of copper plate, zinc plate, and multimeter. So first claim indicates here the component of the invention and the usefulness of the invention. And in second claim, it indicates the process of using such invention. So there are some steps how we can use such invention. Even things may be considered for patent. Earlier, paper clip was patented in US. See the drawing. And it may be claimed like a paper clip made of single piece of metal wire comprising so and so. So we need to frame all aspects of the invention in order to claim it. Whatever is not claimed, that means applicant disclaim. Ballpoint pen patents for regulating ink flow, aperture for holding ink, spiral marking points. All the functional aspects may be covered under this claim part. Polyherboceutical composition for reducing hypertension. So this is a herbal formulation which is helpful for reducing hypertension. It includes several biological resources like it comprising dried aqueous extract of fresh root of Rolfia serpentina, fresh green part of Terminalia arjuna, root of Berevia diffusa, whole part of plant Convolvulus pluricolis. Many times we find that such of the ingredients are well known and the use of such ingredients are also well known, and many times by such common knowledge, that is traditional knowledge, public try to come with some new formulations, and on the ground of obviousness many of such applications are objected and it's a little difficult to get patents over such formulations. Having known ingredients and such ingredients are known for used claim. Form 3. It needs detail of the country, the date of application filed there, and the concerned application number and the status, etc. Even if there is no such applications filed by the applicant, he have to submit this form with nil information. Form 5. The name of applicant, inventor's detail. Here applicant declaring name of all the inventors, and in case where inventor and applicant is the common person, there is no need of such form 5. This is the payment receipt of patent filing. Once we file the patent application, this payment receipt generated. It indicates application number, amount paid, date of application, and remark section, under which we may see title of the invention. After payment receipt, there is a application filing receipt that indicates application type. There are 9 types of application and the priority details like priority number, priority date, and priority country. Further, it indicates name of the applicant, application number, date of filing, and applicant address. So to promote e-filing of patent application, the fee for online filing has been kept at 10% lower than that for physical filing, and for patent fee for educational institution, it's reduced by 80%. New numbering format for patent application in India, where 4 times Y denotes 4-digit for year of filing. J denotes jurisdiction, 1 for Delhi, 2 for Mumbai, 3 for Calcutta, 4 for Chennai. T denotes type of application, 1 for ordinary, 2 for ordinary divisional, 3 for ordinary patent of edition, 4 for conventional application, 5 for conventional divisional application, and so on. And 6 times N are the serial number of the patent application, which are applicable for all patent office in India. After filing applications, there are some post-filing requirement like publication of the application and examination of the application. I will cover such details in next presentation. Thank you.